In Arizona, real estate, mortgages, and deeds of trust serve as the primary financing mechanisms used to secure loans for property purchases. While deeds of trust are more common, traditional mortgages are still used in certain transactions. Understanding how a mortgage functions, along with the rights and responsibilities of the mortgagor, borrower, and mortgagee, lender, is essential to maintaining compliance and protecting ownership interests. Mortgage defined, ARS, BAR 33702. Under ARS, Year 33702, a mortgage is a legal instrument that creates a lien on real property to secure the repayment of a debt. Unlike a deed of trust, a mortgage involves only two parties, the mortgagor, borrower, and the mortgagee, lender. The borrower retains both legal and equitable title to the property, while the lender holds a lien until the loan is paid in full. If the borrower defaults, the lender must initiate a judicial foreclosure, a court-supervised process requiring a lawsuit to obtain the right to sell the property. This statute establishes that the mortgage acts purely as a lien and does not convey title. It also provides that a mortgage can only be enforced if the borrower fails to fulfill their repayment obligation under the terms of the promissory note. Mortgagor. Rights. ARS. Paragraph 33703. The mortgagor, defined under ARS. Paragraph 33703, retains several key rights, including the right of possession, the right to use and enjoy the property, and the equitable right of redemption, which allows the borrower to reclaim the property by paying the full debt, interest, and costs before foreclosure is finalized. This statute also clarifies that a mortgage does not transfer ownership, but rather secures the debt against the property as collateral. Even if foreclosure proceedings begin, the mortgagor retains ownership until a final judgment and sale are completed. The law further provides that any deficiency judgments, the difference between the loan balance and foreclosure sale price, may be limited or barred depending on the property type and loan structure under Arizona's anti-deficiency statutes. ARS, Paragraph 33-814. Mortgagee, defined. ARS, Paragraph 33702. Under the same statute, ARS, Paragraph 33702, the mortgagee is the lender, creditor, or financial institution that provides financing and holds the lien on the mortgaged property. The mortgagee's interest is protected through the recording of the mortgage, which provides constructive notice to the public that a lien exists. The mortgagee has the legal right to enforce the terms of the loan, collect payments, and foreclose if the mortgagor defaults. During foreclosure, the mortgagee must comply with Arizona's procedural requirements, including proper notice and judicial oversight, ensuring fairness and transparency in the enforcement of the lien. Homeowner insurance on mortgaged property. ARS, Paragraph 20-475.01. Under ARS, Paragraph 20-475.01, any property secured by a mortgage or deed of trust must maintain adequate homeowner's insurance coverage to protect the lender's financial interest in the property. This statute prohibits a lender or mortgage servicer from requiring the borrower to purchase insurance coverage that exceeds the replacement cost of the property's improvements. It also regulates force-placed insurance, preventing lenders from imposing unnecessary or excessive coverage costs on borrowers. The purpose of this statute is to ensure that both the lender's and borrower's investments are protected in the event of property damage or loss due to fire, theft, or natural disasters, while also preventing abuse through overinsurance practices. Together, these statutes establish the foundation for mortgage lending practices in Arizona. They clarify the rights and obligations of both borrowers and lenders, ensure fairness through judicial foreclosure procedures, and protect both parties' financial interests through mandated insurance coverage.